Wanjiru, is holding brief for Mother Karua. Who? She's a Jiro, is holding brief for Mother Karua. Manzo is holding brief for Kalonzo Musyoka. Daniel Amalemba is for the accused.
Present,
Associate Kihara has just come. He's appearing for the accused. I'm not ready.
Neither of them, so either side of the eye actually submitted, but I was able to capture the same authorities. I think nowadays it's so easy to get those authorities. So then I'll proceed with the ruling. So Jayne Kihara, herein after I referred to her as a suspect, was arraigned in court on this on the 18th day of July 2025, to take plea on the offense of offensive conduct conducive to breach of peace, contra section 94, subsection 1 of the Penal Code. The particulars thereof has been succinctly set out that on the 8th day of July 2025 at Nairobi City, within Nairobi County, being in a public gathering, uttered words to wit, open quote. I want to talk about Naivasha because I know those goons were transported in NYS bus in a place called Karangita. They were dropped there. In town, they were brought in trucks in Maimau. So all these people, nobody knew them. As I condole with the bereaved and also empathize with those whose properties were destructed, I want to tell President Ruto, this is not a war. You can win unless you want to destroy this country. It is about the youth. It's about young people who you went around promising heaven, and what you are doing now is digging deep so that they go under. It will not happen. In Naivasha, they killed 1, 3 are in critical condition, and as my colleagues have said, police are doing anything. They didn't try to arrest the goons. They're not doing anything. They didn't try to arrest the goons. You could see in the place goons working with them. So it is not anything that is going to end. We as Kenyans are prepared to prepare our country so that you cannot. We as Kenyans are prepared to prepare our country so that you cannot be drowned by one single person because you think you're so powerful, yet you have the power which we give you. You cannot use the same power to destroy us and destroy the country. End of quote. I'm quoting verbatim with intent to provoke breach of peace. So I take judicial notice that the suspect is a sitting and current MP, Member of Parliament representing Naivasha constituency. The suspect was represented by a battery of counsel. They were led by Dr. Kalonzo Musyoka, Senior Counsel, Mr. Muturi, Mr. Kihara, Mr. Kirabu, Mr. Ndego Njiru, Mr. Wairegi, Mr. Malemba, Mr. Nyambu, Mr. Wambugu Njohi, Mr. Mageto, et al. They're quite a number. So the state, on the other hand, was represented by Ms. Nora, Mr. Witi JV, Ms. Sonia, and Mr. Momani. So in its application, canvassed orally on the 18th day of July 2022, counsel for the suspect have vivaciously opposed the suspect from taking plea. So that is the canon and quintessence that this court is called upon to make a determination on. Dr. Musyoka, Senior Counsel, has urged that on the casual glance of the charge sheet, the suspect is charged with the offense of offensive conduct, contra section 94, subsection 1 of the Penal Code. Senior counsel adjured that this is purely political persecution and that the alleged utterances falls within the constitutional realm and orbit of freedom of expression and press, and furthermore, the particulars does not disclose any offense. He poignantly supplicated that other people or politicians have said worse statements, thereby imploring selective and or discriminative prosecution. Senior counsel was appalled by how the arrest was conducted in terms of the public resources used and the numerical force that was used against the backcloth of the misdemeanor charges that now the accused has been arraigned. And therefore he espoused that the acts by the enforcement agency were all unconstitutional. On his part, Mr. Kihara beseeched that the particulars of the offense as well do not disclose the ingredients and were unconstitutional. He submitted that being a member of parliament, the suspect was a mouthpiece of our constituents and which she exercised by dint of Article 33 of the Constitution. Mr. Ndegonjiru guarded this court on the enforceability of rights within the refraction of the constitutional imperative and the dictum vis-a-vis the statutory provisions and the doctrine of stare decisis. He entreated that pursuant to Section 8(1) of the Magistrates Court Act, this court is close to the jurisdiction to hear and determine applications for redress of a denial, violation, or infringement of or threat to a right or fundamental freedom in the Bill of Rights. He thus urged the court to invoke Article 33 of the Constitution in delineating whether the charge sheet borders on a threat to a right or violation of fundamental principles. Further, learned counsel Mr. Njiru, our most stringent argument is that the statutory provisions must be symmetrical and harmonious with the Constitution by dint of Section 7 of the 6th Schedule and Article 10 of the Constitution on national values and principle of governance. He thus avowed that this court has the jurisdiction in entertaining the instant application relating to the threat, the denial or violation of the suspect rights in the contextual milieu of Article 33 of the Constitution on the freedom of expression as juxtaposed with the Section 94(1) of the Penal Code. He buttressed further that the particulars do not disclose an offense for the suspect to comprehend to the charges she is facing. Counsel further argued on the limitation of rights and fundamental freedoms under Article 24 of the Constitution, submitting that rights or fundamental freedom cannot be limited only to the extent that the limitation is reasonable, justifiable in an open, democratic, and civilized society. Counsel also made reference to Article 19, 20, and 27 of the Constitution.